And we're not quite as quick as the English, who put into place a practical abolition, or a de facto abolition, I should say, in 1965, that is then regularized in 69. But we'd be ahead of France, ahead of Canada, certainly ahead of Russia. Which would, again, given what we were just saying a few minutes ago about all the reasons that we might expect the U.S. to be different than Europe, instead, 2 votes change on the Supreme Court, and the U.S. falls right into line. Now you might say, well, wait a second. Professor Simon, we read Gregg. We know that in the immediate aftermath of Furman versus Georgia striking down all existing death penalties, 35 states enact new death penalties. Something like 700 people are sentenced to death, again, by the time the court hears the Gregg set of cases. Wouldn't there have been a huge backlash, and wouldn't we still have a death penalty today? Well, of course, it's always possible for the Supreme Court to reverse itself. As I'll show you in a moment, or remind you in a moment, it did in Furman, having just a year earlier declined to find the death penalty in California unconstitutional. But you would have had 5 votes saying that the death penalty is always unconstitutional. That would have meant that states did not have an invitation to write new death penalty statutes. Now, they could have done it, but unless on appeal from one of those new death sentences, one of these justices switched votes, or a justice left the court and was replaced by a new justice, you would have sort of what you have in Roe versus Wade, a case that lots of people hate, a case that generates lots of political protests and other kinds of political effects, but which over the course of, 40 years, has essentially taken abortion, or at least the complete criminalization of abortion, off the table of American states. And we could well have ended up with that very same outcome in the case of abolitionism of the death penalty. After all, as we talked about last time, in each of these countries, at the time of abolition and for decades afterwards, solid majorities, sometimes 2-to-1 majorities in those countries, wanted to go back to the death penalty. These, in the case of these countries, these weren't even constitutional decisions, right? Until you get to the Optional Protocol 6, and the European Convention on Human Rights suddenly, through that optional protocol, creates essentially a constitutional barrier to any resumption of the death penalty. But until that moment, any of these countries could have returned to the death penalty and frequently talked about it, but none of them did it. Now, I say that only because, as much fun as I think it is at any rate, to use social theorists to try to understand how one society ends up in a different place than another, we also always have to have our eyes open to how politics and law at a more medium and micro level can result in outcomes that don't seem predetermined, right? Because from this point of view, the United States and Europe look like they're following a very similar trajectory. By the end of the 19th century, the death penalty has pretty much been narrowed down to homicide and maybe a handful of other very serious violent felonies. It's been moved inside the prison, and there's no more public execution. It's become more lenient is the wrong word. It's become less conspicuously painful in its execution. All those things we talked about last time are true for the United States and for Europe. If we look at numbers, it goes down and down and down. So there's about 300 death sentences a year on average in the 30s, and it just goes down to the point where by the 60s, there's less than 100 people sentenced to death in the entire decade of the 60s, and that's before the Supreme Court intervenes. All right, so you get an image of a death sentence narrowing and at the same time becoming more and more limited in its application, finally being essentially abolished by elites who decide to take the pain of some populist unhappiness to finally remove what is seen as a culturally and perhaps morally problematic institution. All of that would have fallen into the exact same pattern had the 2 votes I'm talking about switched. And there's certainly, at least in my view as a student of the Supreme Court, nothing incredible about the possibility that those 2 votes could have come out the other way. So before we look at Furman in some more detail, and Gregg and the system that emerged out of Furman and was legalized or constitutionally validated by the Gregg decision, let's think a little bit about the significance of the turn to the Supreme Court, which is an important difference. If we look back for a moment at the previous slide, in all of these cases, with the exception of Russia in 91, these abolitions all take place as a result of majoritarian political institutions, primarily parliaments and the executives that they put into power, deciding to abolish the death penalty. Germany, also is a constitutional abolition. When they they formulate a new constitution, they eliminate the death penalty. Russia essentially is coerced by the European Convention, the European Community. If they want to take steps to become part of Europe, they have to abolish the death penalty, so they do. But in these other countries, by and large, it is a political process. It is only, or distinctly the United States, that makes it takes a legal road to abolition. And one thing to notice is how it introduces some new arguments into this now 3-century-long running debate about the death penalty. So we go back and just review for a moment what we might call the arguments since Beccaria on both sides, sort of the abolitionistas and the retentionistas, as I'm calling them here. What we see is that there have been a fairly repetitive series of arguments that have been in place since pretty much the 18th century. So Beccaria gives us the argument that the death penalty doesn't deter, and that it may even have perverse consequences, like brutalizing people and making them less, more comfortable with violence, and therefore harder to deter. Beccaria also introduces an individual rights argument, the notion that the state doesn't have the authority to terminate the life of one of its subjects. Beyond, Beccaria doesn't quite make it, but other people in his age and his period essentially talk about cruelty, the cruelty of the death penalty, and especially the way it's carried out in the 18th century, very painfully and publicly. It's not till really the 20th century that you get the newest, the first new argument in a couple hundred years, and that is the focus on wrongful conviction that emerges in the 20th century with the problem of forensic evidence gone wrong. Looking at the retentionist side of the argument, we also find tremendous stability over time. So from the beginning, some people are responding to Beccaria on the deterrence argument, basically as we do today, just going back and forth about whether the death penalty deters or not. You say it doesn't deter because nobody believes they're going to get it. I've never seen anyone, appealing a life sentence trying to get a death sentence, so obviously it must deter because people fear it more than they fear a life sentence. That kind of argument goes back and forth today, sometimes with more statistical sophistication than in the 18th century, but sometimes not. And it was going on then, so we have to count deterrence on both sides of the equation. Individual rights also points to a kind of retribution argument of the sort that Kant made when he said that it's actually a right of the prisoner to be executed. That is, a society must give them the respect of their autonomy that is due them, and therefore carry out an execution for them having violated the legal regime that they agreed to uphold, and therefore respect them. That's a sort of a individual rights argument for the death penalty, if you will. Thirdly, there's a sort of biblical sanctions argument. The death penalty received some specific sanction from the Bible. And again, theologians debate a lot about the meaning of those phrases in Genesis, but the argument has certainly been around for a while. The only new argument you get at the beginning of the 20th century, and made most adamantly by the Nazis, is that the death penalty is simply legitimate if it is an expression of the popular will to express their desire for expiation or moral outrage that they feel through death. The reason I underscore these is because when we look at what happened in America and the process of taking abolition to court, one of the things we're going to see is that a whole new set of arguments come into play. Some of the old arguments come into play as well. So we have an argument about retribution and deterrence, but we also begin to talk about some new topics. One of those topics is race discrimination. There's just not a lot of talk in Beccaria or in 19th century or really in early 20th century abolitionist discourse about race discrimination. This is partly an artifact, this emergence of race discrimination, of the fact that in the period of, in the post-World War II era, the U.S. legal system and courts in particular were obviously very much influenced by the whole controversy about legal segregation and the Brown versus Board of Education decision and the whole wave of constitutional equal protection decisions that followed it, which made racial discrimination, once legally protected in America, illegal and sometimes even a crime. By the time the death penalty was being challenged in court in the 1960s and 70s, the problem of race discrimination was one that the courts were very concerned about, and the pattern of the death penalty being racially skewed was one that was very clear, especially when we looked, that is when experts looked at death sentences handed down for the crime of rape, which was essentially the crime other than murder for which people in the United States in the 20th century were most likely to be executed for. And when you looked at executions for rape, what you found is that essentially 100% of the victims of the death penalty were typically African American, sometimes Latino, but generally non-white, almost always non-white, and almost always for the rape of a white victim. And so there you had a very distinct pattern of racial discrimination, one that was certainly on the mind of the courts and the lawyers. A second kind of argument that we haven't seen before, I should say, in the development of the abolitionist debate is the issue of due process, or to put it the other way, arbitrary process or arbitrariness. An important part of any legal system is the idea of the rule of law, that whatever kind of decision is going to be made, it's going to be made based on existing legal rules that are imposed and executed fairly. By the time the death penalty came to the attention, or the active consideration, I should say, of the U.S. Supreme Court in the late 1960s, the Supreme Court had again been through a recent revolution of litigation about arbitrariness and due process, and specifically in the criminal justice field. And some of you may have studied this in your other legal studies classes, but this is where you have decisions like Miranda versus Arizona, holding that people who are in custody, who are being interrogated by the police, have a right to be warned about their right to counsel and their right to remain silent. Matt versus Ohio, which says that police need to get a warrant before they can search your property, etc. There was a whole series of decisions in the criminal field aimed at due process and making the system less arbitrary. And again, that raised an issue that hadn't been, it certainly was part of the Beckerian discourse, but there it was framed under deterrence, right? If you have a system that's subject to all these capricious appeals and mostly pardons, it's not going to deter people very well. It wasn't raised as a separate fairness issue. Thirdly, you began to get a number of arguments made about the cruel and unusual punishment language of the Eighth Amendment. And as we'll see as we talk more about it, this was a potential problem for lawyers attacking the constitutionality of the death penalty. Why? Because the Eighth Amendment, which became part of our Constitution in 1789 as part of the Bill of Rights, was written at a time and by authors who clearly did not think that they were making the death penalty unconstitutional. How do we know that? We know that because they referred to the death penalty in the Constitution, noting, for instance, that people convicted of treason can only receive the death penalty and not other punishments that were considered in some ways add-ons to the death penalty in England, such as forfeiture of your properties and the fact that your descendants cannot inherit your property or wealth. So we know from a variety of contextual factors that the people who authored and voted on the Bill of Rights, the Eighth Amendment, certainly did not think that they were finding the death penalty unconstitutional. The Supreme Court had considered the death penalty on something like 8 to 12 different occasions between 1789 and 1969, and never showed even the slightest doubt that the death penalty itself was anything but constitutional. They asked questions like whether it was constitutional to hang somebody twice or electrocute them twice. They asked questions like whether or not the death penalty for a particular crime was constitutional, but they had never shown any doubt that the death penalty would not itself be inherently cruel and unusual. Nonetheless, by the time you got to the late 1960s, you began to get some arguments building out of the Eighth Amendment, especially arguments focusing on what an earlier case called evolving standards of decency. True enough, in 1789, people would not have questioned the death penalty, at least for an appropriate crime, but arguably a society advances in its moral values and in its sense of humanity over time, these standards of decency. And the question would be, does the death penalty today in 1969, 1971, 1972, does it today violate our standards of decency? So these are distinctive arguments. They are not the kind of arguments that you would make to a parliament, by and large. They're arguments that are very court-centered, and as I've noted, tied in with both existing trends in legal development, civil rights law, due process law, and concerns about distinctively legal institutions like the jury, right, which was an earlier generation solution to making the death penalty less common, give the jury discretion who should die, which they did not have in England, but which by the end of the 20th century seemed to add a great deal to the arbitrariness and possibly the racial discrimination factor. Now, I'm going to bring their face up again. This is a picture of, again, I'm sorry so many of these slides do not, the files are too small to project at this size, but this is Anthony Amsterdam, undeniably the dean of American death penalty lawyers in the abolitionist camp. He, at the time, I believe, was a law professor at Stanford, now at NYU, when he led the team that wrote the Furman versus Georgia brief to abolish the death penalty. Here's in some ways his successor as the country's perhaps preeminent death penalty defense litigator. That's Brian Stevenson, who's also now at the NYU Law School. But in any event, Amsterdam very much came out of the civil rights tradition. He was working with a team of lawyers that were part of the NAACP Legal Defense Fund, which had led the charge on school desegregation. So he certainly was very much aware of this civil rights background. In any event, the first challenge that Amsterdam and his NAACP Inc. Fund team brought successfully to the Supreme Court was a challenge to the California death penalty. And that produced a decision in 1971 known as McGautha versus California. And in McGautha, a divided court refused to hold the California death penalty unconstitutional against more or less the host of arguments I just suggested to you. And the key vote there, and the author, therefore, of the key opinion in that decision, Justice Harlan, basically makes the point that the death penalty is inherently unsubjectable to definitive and absolute rules. Quote, to identify before the fact those characteristics of criminal homicides and their perpetrators which call for the death penalty, and to express these characteristics in language which can be fairly understood and applied, appear to be tasks which are beyond present human ability. Now, you might have thought, well, if it's beyond present human ability, then maybe the death penalty should be abolished. But what Justice Harlan was arguing was, we can't ever make the death penalty absolutely reliable and predictable in terms of who's going to get it. There's an element of human judgment about who deserves to die that a jury needs to make that can never be reduced to a set of tick boxes, if you will, that a jury's going to go through. So either we have to live with the death penalty that's going to be fairly arbitrary, or we should destroy it. And he came down the side of let's keep it, but realized that it's never going to achieve this kind of rational standard. But a year later, only a year later, the court decided to revisit the death penalty issue, and they put together a set of test cases basically that were considered clean. And by clean, I mean they didn't have other legal issues in them. The death sentence has been produced by a legally proper trial, etc. The only issue would be, is the death penalty a valid punishment under the Constitution for this kind of crime? And they actually, because there were still death sentences being handed down, at least theoretically, for robbery and rape as well as homicide, they put together a trio, I think, of rape, robbery, and homicide, Furman being the homicide case, or at least one of two homicide cases. And they made a deliberate decision to pick death penalty cases that weren't too atrocious, or on the other side, ones that were too moderate in their violence. They wanted sort of cases from the middle of the run, as it were, so they could solidly test whether a majority on the Supreme Court would find the death penalty as it existed in the United States constitutional. And as in 1972, much like the slide I put up a few minutes ago, the Supreme Court did declare that all existing death penalties in the United States violated the Eighth Amendment. So we were essentially on the verge of being in that slide that I showed you a minute ago. The problem was it was a very divided court. There were actually 9 separate opinions, and there are 9 justices, so even for me, I can do the math on that. Every justice wrote their own opinion, and it's very hard to see a pattern when everyone writes their own opinion. But we know there were basically 3 groups of them. There were 3 justices that thought that the death penalty was unconstitutional in all instances. There were 3 justices on the other side that basically said the Supreme Court has no business striking down a penalty that has existed since the Constitution was formed, and when there's no clear evidence that it's violating any normal clause of the Constitution, other than this very general notion of cruel and unusual punishment. And then you got 3 justices in the middle who basically decided that, or maybe it's just 2, I got to double check my notes, who thought that the death penalty as applied in the cases that they looked at were unconstitutional, but that left open the possibility that corrected and modified, the death penalty might indeed be legitimate under the cruel and unusual punishment clause. So let's take a look at these arguments. And I want to focus here on the swing justices, who were Justices Potter Stewart and Byron White. As you can see, they were on the court for substantial terms. I can tell you more about them individually if you have questions, but what I want to focus on here is their rationale for voting to strike down the then existing death penalties. For both of them, the real problem with the death penalty is that it had become so unique and rare that it was almost inherently freakish. Justice Stewart analogized it to lightning strikes. Like, you can't explain why one person gets struck by lightning but not another person. It's sort of an act of God. The death penalty seemed like that to him. Looking at a bunch of murders, one gets a death penalty, 9 others don't. Can you say why that one got it and the other 9 did not? No, it doesn't seem to be any clear aspect of the crime or the criminal that explains it, except, Stewart worried, race. Race might be the one thing that helps explain why the one person got selected out, certainly in the case of rape, where virtually all of the people sentenced to death for rape were African American. Justice White also took the view that given how few cases actually resulted in a death penalty, there were only 100 death sentences in the entire decade of the 60s, even though there were about 15,000 murders on average a year and thousands of convictions of first-degree murder. If you're talking about 1 out of 1,000 or 2,000, how could you come up with an explanation for that? That's almost inherently going to be arbitrary. There's not going to be any meaningful basis, as he put it, to distinguish the few cases in which it is imposed. So for them, under those conditions, the death penalty was unconstitutional. To execute somebody when you couldn't explain to that person why they got the death penalty and these other people did not, made the death penalty unconstitutional. It was not inherently unconstitutional. A somewhat different approach was taken by the justices. I'm moving now to the justices that thought that the death penalty was inherently unconstitutional. And while they all joined each other's opinions, they also expressed somewhat and interestingly different views. One of the most interesting, certainly Justice Thurgood Marshall, one of our greatest justices of the 20th century. Certainly he had been the chief counsel for the NAACP when Brown versus Board of Education was argued. President Johnson appointed him to the court in 1967. And he made essentially 2 points about why he thought the death penalty had become at least inherently unconstitutional, both of which serve to distinguish the present from the founders' generation. He said that capital punishment serves no rational purpose. That is, whatever goals of deterrence, incapacitation, retribution might once have relied on the death penalty, there are other ways to achieve now because of the strength of the prison system. But he went on to say that even if capital punishment is not excessive, that is, even if it does serve a purpose that no other punishment can adequately serve, it nonetheless violates the Eighth Amendment because it is morally unacceptable to the people of the United States at this time in history. So Justice Marshall was arguing that the death penalty could not be fixed. It was time to pull the plug on it for 2 reasons. One, because there were other ways to accomplish all the things that could be said to be the goals of the death penalty. It was excessive. But even if it wasn't excessive, even if you thought there might be some legitimate reason that the death penalty served a purpose that could not be served by a different penal exercise, it simply was morally unacceptable to the people of the United States at this time in their history. Now notice, I think 2 points I want to make about this. One, notice that Marshall's arguments, both of them, essentially raise empirical claims about the death penalty. One is that it doesn't add anything to deterrence, say, which is, at least in principle, an empirical issue that we could try to determine.